Give this content a thumbs up by hitting the like button. And subscribe to the channel to get notification of further content regarding GCC past examinations questions and solutions. The Act questions and recommended solutions. Taken from November 2014 examination. Question 1. Part 1.1. Define the following terms as given in the Act. Approved Inspection Authority, AIA. Approved Inspection Authority means an inspection authority approved by the Chief Inspector, provided that an inspection authority approved by the Chief Inspector with respect to any particular service shall be an approved inspection authority with respect to that service only. Inspection Authority. Inspection authority means any person who with the aid of specialized knowledge or equipment or after such investigations, tests, sampling, or analyses as he may consider necessary, and whether for reward or otherwise, renders a service by making special findings, purporting to be objective findings, as to a. the health of any person, b. the safety or risk to health of any work, article, substance, plant, or machinery, or of any condition prevalent on or in any premises, or c. the question of whether any particular standard has been or is being complied with respect to any work, article, substance, plant, or machinery, or with respect to work or a condition prevalent on or in any premises, or with respect to any other matter, and by issuing a certificate, stating such findings, to the person to whom the service is rendered. Premises. Premises includes any building, vehicle, vessel, train, or aircraft. Prescribed. Prescribed means prescribed by regulation. Standard. Standard means any provision occurring a. in a specification, compulsory specification, code of practice or standard method as defined in Section I of the Standards Act, 1993, Act No. 29 of 1993, or b. in any specification, code, or any other directive having standardization as its aim and issued by an institution or organization inside or outside the Republic which, whether generally or with respect to any particular article or matter and whether internationally or in any particular country or territory, seeks to promote standardization. Part 1.2. For what may you not make any deductions from an employee's remuneration or make an employee pay for? Solution. Anything which he is in terms of this Act required to provide or to do in the interest of the health or safety of an employee. Part 1.3. When questioned by an inspector during an incident investigation, a health and safety representative told the inspector that a broken guard on the machine was removed for repairs 6 months ago and not replaced to date, yet they had to carry on using the machine without the guard. What steps may you not take against that health and safety representative? Solution. No employer shall dismiss an employee, or reduce the rate of his remuneration, or alter the terms or conditions of his employment to terms or conditions less favorable to him, or alter his position relative to other employees employed by that employer to his disadvantage. Part 1.4. The Minister has by notice in the Gazette incorporated the Health and Safety Standard Sens 241, Standard Specification for Water for Domestic Supplies in the Facilities Regulations. 1.4.1. What is the legal standing of this health and safety standard? Solution. Health and safety standard is deemed to be a regulation. 1.4.2. Since the incorporation of this health and safety standard, it has been amended but no further notices were gazetted in this regard. What is the legal position of the amendment? Solution. Whenever any health and safety standard is at any time after the incorporation thereof as aforesaid, amended or substituted by the competent authority, the notice incorporating that health and safety standard shall, unless otherwise stated therein, be deemed to refer to that health and safety standard as so amended or substituted, as the case may be. 1.4.3. How can you find out which standards have been incorporated into the regulations? Solution. The Chief Inspector shall keep a register of particulars of every publication in which a health and safety standard incorporated in the regulations under subsection 1, and every amendment or substitution of any such health and safety standard, was published, and also of the place in the Republic where such publication is obtainable or otherwise available for inspection, and he shall make that register or an extract therefrom available free of charge to persons having an interest, for inspection. Question 2. You are manufacturing and installing refrigeration equipment in the retail business. In your head office where the administration, design, and sales are managed, there are 28 employees. There are 79 employees in the factory which is on a different premises than the offices. There are 27 employees doing the installation, commissioning and maintenance of the refrigeration equipment, and every day they go out from the factory. In the process of designating health and safety representatives at your workplace, you have consulted and agreed with the employee representatives about the arrangements and procedures of nomination, period of office and designation of health and safety representatives. 2.1. Who are eligible to be designated as health and safety representatives? Solution. Only those employees employed in a full-time capacity at a specific workplace and who are acquainted with conditions and activities at that workplace or section thereof, as the case may be. 2.2. How many health and safety representatives must you appoint in the head office? Solution. At least one health and safety representative for every 100 employees or part thereof. 2.3. How many health and safety representatives must you appoint in the factory? Solution. At least one health and safety representative for every 50 employees or part thereof, provided that those employees performing work at a workplace other than that where they ordinarily report for duty, shall be deemed to be working at the workplace where they so report for duty. Appoint 2 reps. 2.4. When must you appoint more health and safety representatives? Solution. If an inspector is of the opinion that the number of health and safety representatives for any workplace or section thereof, including a workplace or section with 20 or fewer employees, is inadequate, he may by notice in writing direct the employer to designate such number of employees as the inspector may determine as health and safety representatives for that workplace or section thereof in accordance with the arrangements and procedures referred to in subsection 2. 2.5. Do you have to appoint a health and safety committee in the head office? Solution. An employer shall, in respect of each workplace where 2 or more health and safety representatives have been designated, establish 1 or more health and safety committees and, at every meeting of such a committee as contemplated in subsection 4, consult with the committee with a view to initiating, developing, promoting, maintaining, and reviewing measures to ensure the health and safety of his employees at work. The answer is no. 2.6. Do you have to appoint a health and safety committee in the factory? Solution. An employer shall, in respect of each workplace where 2 or more health and safety representatives have been designated, establish 1 or more health and safety committees and, at every meeting of such a committee as contemplated in subsection 4, consult with the committee with a view to initiating, developing, promoting, maintaining, and reviewing measures to ensure the health and safety of his employees at work. The answer is yes. 2.7. Who may be designated as a health and safety committee member? Solution. All designated health and safety representatives and persons nominated by an employer. 2.8. How many members will you have on the health and safety committee? Solution. A health and safety committee shall consist of such number of members as the employer may from time to time determine, provided that a. If one health and safety committee has been established in respect of a workplace, all the health and safety representatives for that workplace shall be members of the committee. b. If 2 or more health and safety committees have been established in respect of a workplace, each health and safety representative for that workplace shall be a member of at least one of those committees, and c. The number of persons nominated by an employer on any health and safety committee established in terms of this section shall not exceed the number of health and safety representatives on that committee. 2.9. How often must the health and safety committee meet? Solution. A health and safety committee shall hold meetings as often as may be necessary, but at least once every 3 months. 2.10. Who may the health and safety committee co-opt on the committee? Solution. A. A Health and Safety Committee may co-opt one or more persons by reason of his or their particular knowledge of health or safety matters as an advisory member or as advisory members of the committee. B. An advisory member shall not be entitled to vote on any matter before the committee. June 2014 examination. Question 1. Part 1.1. Define the following terms as given in the Act. Hazard. Hazard means a source of or exposure to danger. Inspector. Inspector means a person designated under Section 28. Inspection Authority. Inspection authority means any person who with the aid of specialized knowledge or equipment or after such investigations, tests, sampling, or analyses as he may consider necessary, and whether for reward or otherwise, renders a service by making special findings, purporting to be objective findings, as to a. The health of any person. b. The safety or risk to health of any work, article, substance, plant, or machinery, or of any condition prevalent on or in any premises, or c. The question of whether any particular standard has been or is being complied with respect to any work, article, substance, plant, or machinery, or with respect to work or a condition prevalent on or in any premises, or with respect to any other matter, and by issuing a certificate, stating such findings, to the person to whom the service is rendered. 1.2. Name 2 general duties of an employer to his employees. Solution. Maintain a working environment that is safe and without risks to the health and safety of employees. Provision and maintenance of systems of work, plant, and machinery that, as far as is reasonably practicable, are safe and without risks to health. 1.3. Name 1 general duty of an employer to persons other than his employees. Solution. Every employer shall conduct his undertaking in such a manner as to ensure, as far as is reasonably practicable, that persons other than those in his employment who may be directly affected by his activities are not thereby exposed to hazards to their health or safety. 1.4. Name 1 general duty of a manufacturer or importer regarding articles for use at work. Solution. Any person who designs, manufactures, imports, sells or supplies any article for use at work shall ensure, as far as is reasonably practicable, that the article is safe and without risks to health when properly used and that it complies with all prescribed requirements. Properly used includes to ensure information for safe use is provided. 1.5. Name 1 general duty of an employee at work. Solution. Every employee shall at work a. Take reasonable care for the health and safety of himself and of other persons who may be affected by his acts or omissions. b. As regards any duty or requirement imposed on his employer or any other person by this act, co-operate with such employer or person to enable that duty or requirement to be performed or complied with. c. Carry out any lawful order given to him, and obey the health and safety rules and procedures laid down by his employer or by anyone authorized thereto by his employer, in the interest of health or safety. d. If any situation which is unsafe or unhealthy comes to his attention, as soon as practicable report such situation to his employer or to the health and safety representative for his workplace or section thereof, as the case may be, who shall report it to the employer, and e. If he is involved in any incident which may affect his health or which has caused an injury to himself, report such incident to his employer or to anyone authorized thereto by the employer, or to his health and safety representative, as soon as practicable but not later than the end of the particular shift during which the incident occurred, unless the circumstances were such that the reporting of the incident was not possible, in which case he shall report the incident as soon as practicable thereafter. Question 2. 2.1. Name 2 functions a health and safety representative may perform in respect of the section of the workplace for which he or she has been designated. Solution. A health and safety representative may perform the following functions in respect of the workplace or section of the workplace for which he has been designated, namely: a. Review the effectiveness of health and safety measures. b. Identify potential hazards and potential major incidents at the workplace. c. In collaboration with his employer, examine the causes of incidents at the workplace. D. Investigate complaints by any employee relating to that employee's health or safety at work. E. Make representations to the employer or a health and safety committee on matters arising from paragraphs A, B, C, or D, or where such representations are unsuccessful, to an inspector. F. Make representations to the employer on general matters affecting the health or safety of the employees at the workplace. G. Inspect the workplace, including any article, substance, plant, machinery, or health and safety equipment at that workplace with a view to the health and safety of employees, at such intervals as may be agreed upon with the employer, provided that the health and safety representative shall give reasonable notice of his intention to carry out such an inspection to the employer, who may be present during the inspection. H. Participate in consultations with inspectors at the workplace and accompany inspectors on inspections of the workplace. I. Receive information from inspectors as contemplated in Section 36, and J. In his capacity as a health and safety representative attend meetings of the Health and Safety Committee of which he is a member, in connection with any of the above functions. 2. Shall be entitled to A. Visit site of incidents. B. Attend investigations and inquiries. C. Inspect documents. D. Accompany inspector. E. Be accompanied by a technical advisor. F. Participate in internal health and safety audits. 2.2. Name one function a health and safety committee may perform. Solution. A health and safety committee may make recommendations to the employer or, where the recommendations fail to resolve the matter, to an inspector regarding any matter affecting the health or safety of persons at the workplace or any section thereof for which such committee has been established. 2.3. Name two functions a health and safety committee has to perform. Solution. Hold meetings 3 monthly. Determine proceedings at meetings. A health and safety committee shall discuss any incident at the workplace or section thereof in which or in consequence of which any person was injured, became ill or died, and may in writing report on the incident to an inspector, and shall perform functions described. A health and safety committee shall keep record of each recommendation made to an employer in terms of subsection 1a, and of any report made to an inspector in terms of subsection 1b. 2.4. Name two functions an inspector may perform for the purpose of the Act. 2. Solution. An inspector may, for the purposes of this Act, a. Without previous notice, at all reasonable times, enter any premises which are occupied or used by an employer or on or in which an employee performs any work or any plant or machinery is used, or which he suspects to be such premises. B. Question any person who is or was on or in such premises, either alone or in the presence of any other person, on any matter to which this Act relates. C. Require from any person who has control over or custody of a book, record, or other document on or in those premises, to produce to him forthwith, or at such time and place as may be determined by him, such book, record or other document. D. Examine any such book, record, or other document or make a copy thereof or an extract therefrom. E. Require from such a person an explanation of any entry in such book, record, or other document. F. Inspect any article, substance, plant, or machinery which is or was on or in those premises, or any work performed on or in those premises or any condition prevalent on or in those premises or remove for examination or analysis any article, substance, plant, or machinery or a part or sample thereof. G. Seize any such book, record, or other document or any such article, substance, plant or machinery or a part or sample thereof which in his opinion may serve as evidence at the trial of any person charged with an offence under this Act or the common law, provided that the employer or user of the article, substance, plant, or machinery concerned, as the case may be, may make copies of such book, record, or document before such seizure. H. Direct any employer, employee, or user, including any former employer, employee, or user, to appear before him at such time and place as may be determined by him and question such employer, employee, or user either alone or in the presence of any other person on any matter to which this Act relates. I. Perform any other function as may be prescribed. Investigate incidents. 2.5. An employer is him or herself presumed to have committed an offense which his or her employee has committed unless the employer can prove certain facts. Name these facts. Solution. A. In doing or omitting to do that act, the employee was acting without the connivance or permission of the employer or any such user. B. It was not under any condition or in any circumstance within the scope of the authority of the employee to do or omit to do an act, whether lawful or unlawful, of the character of the act or omission charged, and c. All reasonable steps were taken by the employer or any such user to prevent any act or omission of the kind in question. The employer or any such user himself shall be presumed to have done or omitted to do that act, and shall be liable to be convicted and sentenced in respect hereof, and the fact that he issued instructions forbidding any act or omission of the kind in question shall not, in itself, be accepted as sufficient proof that he took all reasonable steps to prevent the act or omission. The end of questions and recommended solutions for Legal Knowledge Exams Year 2014. Thank you.